Hello, and welcome to the training on legal options for sexual assault survivors. My name is Tamara McClanahan, and I'm a senior staff attorney at SALI, the Sexual Assault Legal Institute. SALI is the litigation branch of the Maryland Coalition Against Sexual Assault. We provide direct legal services to survivors of sexual assault, as well as training and assistance to community partners. For today's objectives, you will be learning the different legal options that may be available to survivors that you work with. You'll be able to understand the differences between the criminal and civil options, as well as the victim's role in the criminal and civil arenas. You'll learn the deadlines to file certain actions, the definitions of sexual offenses that are commonly discussed or filed against perpetrators. And lastly, you'll understand and know when it may be helpful to refer clients to SALI or reach out to us for assistance. As we go through our legal options, it's important to keep in mind the key differences between the criminal and civil cases. For a criminal case, the state's attorney is the party bringing the criminal charges against the perpetrator. The victim is not a party to the case, but the victim is a special witness. This means that the victim is not responsible for proving the case, is not responsible for subpoenaing evidence, and has no control over how the case is presented in court. Ultimately, it's the state's attorney's burden to prove beyond a reasonable doubt that the perpetrator committed the crime. This means that no reasonable person could have doubts that the perpetrator is guilty. The ultimate goal of a criminal case is some type of punishment, whether that is imprisonment, probation, or a fine. In contrast, for civil cases, the survivor is the party bringing the lawsuit against the perpetrator. So the victim is an actual party to the case and would be responsible for presenting the case in court, subpoenaing witnesses, presenting any evidence, things like that. Depending on the type of case, the burden of proof is either preponderance of the evidence, meaning more likely than not, or clear and convincing evidence. And it is the victim's responsibility for meeting that burden. Lastly, in a civil case, the ultimate goal is either money damages or an injunction, which is a court order to do or not do something. For survivors of sexual assault, it's important that all of the legal options have safety and privacy attached to them. So no matter what the relationship is or what the legal option we'll be discussing, there will be some safety aspect in order to protect the survivor from further abuse. We're also going to talk about financial compensation, how sexual assault may affect a survivor's housing rights, whether a victim can apply for legal status for immigration as a result of the sexual assault, how sexual assault at work or school may impact a victim's options. And lastly, we'll discuss family law options that may be available to survivors who are married to their abusers or have children in common with them. When people think of safety in a court system, they generally think of peace and protective orders. These are also called restraining orders or stay-away orders in other states. And although people use the names peace and protective order interchangeably, it's important to note that there are distinctions between the two. There are several elements of peace and protective orders that need to be met, and these elements differ depending on what type of order is being sought. So for eligibility, there's going to be differences in the relationships between the parties. The grounds for the peace and protective orders are going to be different acts of abuse or crimes that were committed. The relief is also different based on that relationship between the parties. There may be more relief available to somebody in a protective order versus a peace order. And lastly, the duration, how long these orders can be in effect for. So who qualifies for these orders? Well, for protective orders, there has to be a special legal relationship. So either the parties are married or they were previously married. They may be siblings related by blood, marriage, or adoption. The parties may be related as a parent and a child. Maybe they just have a child in common and were never married. It may also include a vulnerable adult, so somebody filing on behalf of a disabled adult. And then commonly, the relationship is that the parties had a sexual relationship within the last year, or that there's been a sexual assault within the past 6 months. If the parties to the matter have any type of relationship, such as those, then the person filing for the protective order must file for a protective order. They would not be eligible for a peace order. For peace orders, however, there does not need to be any special relationship. And if you do have that relationship, as discussed in the protective orders, then you're actually not eligible for a peace order. So you're thinking more of like friends or neighbors, maybe roommates who have not had a sexual relationship. Peace orders are also available for employers who may be filing on behalf of employees. So for example, if a host is being harassed by a customer, a manager may want to file a peace order on behalf of the host. It's important to note also that for perpetrators who are under the age of 18, a survivor can only get a peace order against them, not a protective order. And the process for getting a juvenile peace order is different than the process we'll discuss in a little bit. So there has to be some reason for requesting a peace or protective order. For protective orders, there has to be some serious bodily harm or fear of imminent serious bodily harm. That means that the harm is going to occur immediately. So most of those bodily harms are going to be assault, choking, punching, hitting, things like that. But it also covers rape and sexual offense, false imprisonment, stalking, revenge porn as well. And those acts may occur against a child or against a vulnerable adult. Peace orders include the same grounds so there's assaults, rape, false imprisonment, things like that. But peace orders also include harassment, trespass, malicious destruction of property, misuse of electronic communications, and visual surveillance as well. So for roommates who have not had a sexual relationship, if there's a concern of roommate A videotaping roommate B, that roommate B may have a ground for a peace order due to that visual surveillance. When filing for a protective order, generally there is no statute of limitations, no deadline to file. The exception to that is if the qualifying relationship is based on the sexual relationship within the last year or a sexual assault that occurred in the last 6 months. Otherwise, if the parties are married by blood or married or related by blood, and the incident occurs 5 years ago, then technically the survivor can still file for a protective order. For peace orders, on the other hand, the offense has to have occurred in the last 30 days. So for clients that come to us on day 31 or 32, if there's no qualifying relationship for a protective order, then they may not have any peace or protective order options. Also for peace orders, the court must find that the respondent is likely to commit the offense again in the future. So if it's a stranger on a bus and that stranger doesn't know where the survivor lives or has never seen the survivor before, doesn't plan to see them afterwards, the court may be hesitant to grant the peace order if it does not believe that the act of abuse will occur again. So what types of relief are available for survivors? For protective orders, it's more expansive, and that's based on the special legal relationship that is required for protective orders. So protective orders can order somebody not to contact, attempt to contact, or harass the survivor. And that includes in person, via telephone, social media, writing. However, can also order somebody to stay away from a residence, a school, um, childcare, a workplace, things like that. More importantly, though, it can order somebody to vacate a home. So if the parties have lived together, or the survivor's name is on the lease, it can order the respondent, that perpetrator, to leave the home and not come back to it for the duration of the protective order. Again, based on those special relationships between the parties, protective orders can also include temporary custody and visitation arrangements, and also emergency family maintenance, which is a legal obligation to support the survivor. That can look like child support or alimony. It can also be an order for the respondent to pay some type of family bills to the home for the duration of the order. Survivors can also request use and possession of a home or a jointly titled car, and also ownership of pets. That is a very common barrier for survivors because pets are children to people. So survivors can request that they have ownership of certain pets as well through the protective order. One of the most important aspects of the protective order, though, is that under federal and state law, the respondent is not allowed to possess any firearms for the duration of the protective order. So if a protective order is granted, it's going to be ordered that the abuser turn over any firearms to local law enforcement and not possess any firearms. Lastly, there is a catch-all provision in the Maryland law, and basically it's any relief necessary to protect the survivor. And that can be something simple, such as the perpetrator can only attend the 12 p.m. mass instead of an 8 a.m. mass. It really depends on the situation and the case, but any argument can be made for that catch-all provision, what's necessary to keep that survivor safe. Peace orders are not extensive. For peace orders, it can order somebody not to contact, attempt to contact, or harass. It will also order that somebody not commit any prohibited acts such as abuse, threats, physical harm, things like that. Peace orders can order a stay away. That stay away can be from a home, a school, workplace. However, peace orders cannot order vacate. So if the parties are roommates and roommate A and roommate B have a lease, the court cannot order that roommate B leave the home and stay away from the home if there's a legal reason for roommate B being there. Counseling is also an option for peace and protective orders. I will say, in my experience, courts are a little hesitant or unwilling to order counseling unless the respondent is in agreement to seeking that counseling. And that counseling can be drug and alcohol, or it can be domestic violence, sexual assault counseling. So after everything is said and done, an order is granted after a trial or the respondent consented, meaning they agreed to the entry of a protective order. How long does it last? Well, for protective orders, they're good up to 1 year. It may be extended for another 6 months for good cause. And good cause can be ongoing legal cases such as family law, custody, divorce cases, or maybe there's an ongoing criminal case, or maybe there was a violation of the order. All of those are considered good cause. Protective orders can be extended for up to 2 years if there's another act of abuse that occurs while the order is in place, or if a subsequent act of abuse occurs within a year from the expiration of the original protective order. They can also be extended up to 2 years if the respondent consents to the entry of that as well. Permanent protective orders may also be an option. if the respondent was convicted and sentenced to at least 5 years for the same act of abuse that the survivor sought the protection order for. The respondent does have to serve at least 12 months of that sentence before the survivor can petition for a permanent protective order. And the relief in the permanent order is not as expansive as the final protective order. It does not include custody or emergency family maintenance, or use and possession of a house or car. Peace orders, on the other hand, are valid for up to 6 months. They can be extended for another 6 months for a good cause. And again, that may be ongoing legal cases or a violation. So the process of seeking a peace or protective order, again, this is going to be different than the process for seeking a peace order against a juvenile. Generally, for juvenile peace orders, you may need to get essentially permission from the state's attorney. So that process is going to be a little bit different. However, assuming that we're getting a peace or protective order against an adult, you can either go to a commissioner's office if it is after court hours. Commissioner's offices are located sometimes at the jail or sheriff's office, maybe the court of the county. Every county has at least one commissioner. Again, if it's after court hours, you can file there. The commissioner has to find that there is a reasonable belief that the act did occur, and then an interim protective order or interim peace order may be granted. If the survivor files a peace or protective order at the courthouse during court hours, they can bypass that commissioner's office and that interim stage. At the temporary hearing, the survivor would go right in front of a judge, would have to provide statements as to what happened, and a judge would have to find that there's a reasonable belief that the act did occur. If a temporary peace or protective order is granted, it will be valid for up to 7 days to allow service on the other party. And that service is required in order to put the respondent on notice that there is this court order, this stay away, this no contact. Protective orders may be filed electronically, depending on the situation. So survivors may file protective orders electronically from domestic violence programs, sexual assault, human trafficking programs, also from hospitals where the survivor is seeking medical treatment, or any other location that is approved by the court. Peace orders do not have that option. They must be filed either via the commissioner or the courthouse. Again, those orders must be served upon the other party before they are essentially valid in effect. The peace orders can be extended for up to 30 days before they must be dismissed for lack of service. For protective orders, they can be extended up to 6 months while awaiting service before the court must dismiss it for lack of service. Generally, these hearings are scheduled every week. For peace orders, the survivor would have to come back every week to court. For protective orders, though, the survivor can request what's called a waiver of appearance. And basically, it's a request to the court that they do not need to show up until that order is served. Once the respondent or perpetrator is served with the temporary protective order or peace order, there will be a final hearing. And at that final hearing, the petitioner or survivor will have the opportunity to present all evidence and testimony. And the perpetrator will also have the opportunity to present any evidence and testimony to why the order should not be granted. Ultimately, then it would be up to the judge to decide whether to grant or deny the peace or protective order. The respondent also has the opportunity to consent, which is agreeing to the entry of the protective order without admitting to allegations in the petition or a judicial finding of abuse. The standard of proof for a final protective order hearing is preponderance of the evidence, meaning more likely than not. So the petitioner does have a little bit higher burden than at the temporary and interim stage. Under Maryland law, victims of abuse, including domestic violence and assault, do have the option to terminate their residential leases early. And they can do that by providing notice to their landlord that they plan to vacate the residence within 30 days. Attached to that notice must be a peace or protective order or a report from a qualified third party. And those qualified third parties include domestic violence and sexual assault advocates or organizations. It may be a psychologist or a social worker, but that does need to be attached to the notice to the landlord. Victims of abuse also have the opportunity to terminate utility contracts or be removed from any account. It's important to note that the survivor will be responsible for the charges up to and including that billing cycle for which they gave written notice. So if the victim gives notice on July 1st that they want to terminate this contract and the billing cycle ends on July 15th, the survivor is responsible for all of the charges up to that July 15th billing cycle. Undocumented survivors of sexual assault do have the opportunity to file for immigration status through a variety of visas. The first one is a U visa, which gives the victim of serious crimes who fully cooperate with law enforcement the right to live and work in the US. For U visas, the victim has to be a victim of a qualifying crime, or it can be a person who is related to the victim of a qualifying crime, so a parent or a sibling. The victim has to have cooperated with law enforcement or prosecution. That does not mean that there needs to be a conviction or a criminal case. It is often that state's attorney may not go forward with a criminal case against the perpetrator, or maybe the perpetrator left the country or can't be found. So it does not require that an actual conviction or an actual criminal case be held. And lastly, the victim must have suffered some substantial physical, emotional, or psychological harm. There is a wait list and a maximum amount of U visas that are granted every year. So there's a $10,000 cap per year on U visas, and the wait list is very long. As of October 1st, 2023, the United States Customs and Immigrations were reviewing petitions that were filed on or before July 31st, 2016. And they do prioritize the oldest petitions. So at the time of this training, we're looking at least 8 years for that U visa to be granted. T visas are similar to U visas, except they are more focused on the human trafficking aspect. So T visas can give victims of human trafficking the right to live and work in the US if they fully cooperate with law enforcement and again have suffered that substantial physical, emotional, or psychological harm. There's also a 10,000 visa cap, but there is no wait list or a very short wait list. As the T visas are focused on the human trafficking aspect, that cap is usually not met. Lastly, there is a VAWA self-petition that allows the survivor spouse of an abusive US citizen or green card holder to petition on their own to maintain their immigration status or go through that process without relying on their abusive spouse. And the purpose of that is to prevent a survivor of domestic violence from being under the control of their abusive spouse and prevent having that abusive spouse use the survivor's immigration status as a means of control. For sexual assault that occurs at a workplace or by a coworker or boss, survivors cannot immediately directly sue the employer in court. They must go through an administrative process first. And that administrative process is usually filing a complaint with the Equal Employment Opportunity Commission at a federal level or a state level. For Maryland, that's the Maryland Commission on Civil Rights. So this administrative process is a precursor to any litigation. Again, it is required before the survivor can sue the employer directly in court. On the federal level, the employer must have 15 or more full-time employees. But on the state level, that's not the case. For Maryland, only one employee is enough, and independent contractors are covered and considered employees for Maryland employment cases. It's important to note that when filing employment complaints, the action is against the employer themselves, not necessarily the perpetrator. And the employer may be responsible for actions committed by third parties if the harassment occurred by a coworker or a customer and the employer doesn't act, or if the harasser is the boss and has control over the survivor's work schedule and pay, or if the employer retaliated after the survivor made a report about the harassment. So the employer cannot fire or demote or decrease pay of the survivor as a result of the survivor reporting the harassment. Some remedies that may be available to survivors who go through the employment route, they may be able to get the responsible person fired from the employer. The employer may be required to update complaint policies. Survivor may receive an award of lost wages or other financial award. It's also possible to get their job back or be promoted depending on what type of discrimination had occurred. At SALI, we can help survivors file claims with the EEOC or with the county and Maryland state equivalent. And this includes helping to identify deadlines to file. Generally, there's a 180-day filing deadline for the EEOC, unless there's a state law that prevents the same discrimination. In that case, the deadline extends to 300 days from the incident. For the Maryland Commission on Civil Rights, there's a 2-year deadline for sexual harassment. So that complaint must be filed within 2 years from the date of the incident. After filing a charge of discrimination, no matter which route you go, there's going to be an investigation to obtain statements from the employee and the employer and to gather any evidence to show that the discrimination did occur. If discrimination is found, either commission may attempt to hold a mediation to reach a mutually beneficial resolution. If that does not work, then usually the employee survivor gets the right to sue the employer in court. Immigration status does not change the right to bring the complaint against the employer. However, it may limit what type of remedy there is to recover. So for example, an undocumented worker may not have the ability to recover lost wages or replacement in the job because they theoretically did not have the legal right to earn those wages to begin with. Sexual assault that occurs by a teacher or a student can impact a survivor's remedies through the education system. So the sexual assault can occur on or off campus, depending on whether the school had some type of control over the setting. So Title IX says that schools cannot discriminate against people on the basis of sex, and sexual assault or sexual harassment does equal sexual discrimination. And this Title IX does apply from kindergarten to 12th grade and higher education. There is an equivalent Maryland law that applies only to the college level. There are currently changes that are being discussed for Title IX. So it's very important to get legal advice if this is an avenue that may be available to a survivor that you're working with. Schools do have the responsibility to respond to sexual harassment and sexual assault claims only if they receive actual knowledge. And usually that is a direct report to the Title IX office. Supportive measures must also be provided for survivors. And that supportive measure can be changing classes, changing dorms, providing a security buddy to walk to class with. And those supportive measures must be offered regardless of whether there is a formal complaint made to Title IX. For the formal complaint process, there will be an investigation. The Title IX office will attempt to interview both parties as well as any witnesses and collect any evidence that is available. There will be several rounds of reports that are made on which the parties can respond to or make any corrections to. After that investigation is completed, there will be an adjudication process or a live hearing in which both parties will be subject to cross-examination from advisors or attorneys. Depending on what happens at that adjudication process, there may be sanctions that are put in place against a perpetrator. And that may include expulsion, maybe suspension, withholding of a degree, or even the requirement to obtain counseling or training classes before re-enrollment. And lastly, each party does have the right to appeal any adjudication decision. And those appeals currently must be made on either procedural irregularity, if there was new evidence that was not previously available, or some type of conflict of interest or bias by a school actor. So again, that administrative process through the school can result in suspension or expulsion. It can also result in academic, housing, or other accommodations. Again, those are supportive measures that are required to be offered. Mutual stay-away orders can also be put in place and are usually put in place for the duration of the investigation and the hearing. And oftentimes those are extended if there is a determination that the perpetrator was responsible for the sexual assault. And again, just as a reminder, there are changes that are coming soon. At this time, the final ruling on the Title IX changes are expected to be released in the spring of 2024, with implementation occurring in the summer of 2024. Lastly, for survivors who are married to or have children with their perpetrators, family law is also an arena for safety and making changes in that relationship. Maryland did change their law in October of 2023. Maryland used to be a fault-based ground state, which meant that there had to be some reason for getting divorced, and it usually passed the blame on one party or the other. And usually that was allegations of adultery or abuse, cruel treatment of one party. But that's been removed. So there are no fault-based grounds for getting divorced in Maryland. Now the divorce is based on either 6 months of separation or irreconcilable differences. And that's an amazing change because it allows survivors of domestic violence a quicker and less contentious way to end the marriage. It's also important to note for the separation aspect, the Maryland law does allow to be considered separated even if the parties are still living under the same roof. But do keep in mind that that may cause safety concerns if the parties are still living together and filing divorce at the same time. So even though the fault-based grounds were eliminated, those fault grounds are still a factor for alimony and monetary awards. So the court will still consider acts of abuse against one party when making decisions about whether there needs to be a financial contribution for the alimony or whether there's abuse against the children when making decisions about custody, things like that. When it comes to custody, there are two aspects. There's legal and physical custody. And legal custody really means the right to decide the major aspects of the child's life. So where the child goes to school, what religion the child practices, if there are any medical treatments that the child will receive. Physical custody more so focuses on where the child is residing. For rape survivors who conceived a child as a result of the rape, they may have the opportunity to terminate the parental rights of the rapist. So to terminate the parental rights, the perpetrator must have been convicted of the act, or the survivor must show by clear and convincing evidence that the rape committed led to the conception of the child. The survivor must also prove that there's clear and convincing evidence that it is in the best interest of the child in order to terminate the rights. And the court will consider the best interest of the child for legal, physical, and termination of parental rights. And those best interest standards do come from case law, and they include things like the relationship between the parties, the relationship of the parties with the children, whether there's any physical or mental disability of a party, things like that. Lastly, child support is a factor for family law. And child support is calculated through the statute, the Maryland Family Law Code. It considers the incomes of both parties, as well as if there are any other financial responsibilities, such as if one party is paying child support for other children or alimony due to another marriage. It'll consider the medical expenses and the schooling expenses of the children as well. And then also it'll consider the physical custody arrangements between the parties. So where the child is living, who has the most overnights, things like that. And this child support calculator can be found online and actually through the Maryland Court Forms website. So that may be an option to kind of check what child support may look like for a party. And child support through that statute can be deviated from. So a judge can make a determination, for example, if one party is voluntarily impoverished, so they're not working on purpose, the judge may make a ruling to say that that party actually could make a certain amount and use that certain amount as a potential income for that party. So again, just a refresher, all of those options that we just reviewed were civil options, and that's where the victim is a party in the case. The victim is responsible for presenting the evidence and bringing the case in front of the court. We're now going to switch to the criminal system and the criminal aspect. So for these this next option, the victim is just a witness in the case and not actually bringing any of the charges. But we are going to talk about some of the charges that may be brought against a perpetrator. So there are essentially two ways to report a crime. The first one is going straight to law enforcement and reporting the crime. At that time, an investigation will start, and law enforcement will speak with the witness, gather any evidence, and attempt to speak with the perpetrator at that time. If too much time has passed, or if the victim does not want to go to law enforcement directly, they do have the opportunity to file what's called an application for statement of charges with the commissioner's office. And that's the same commissioner's office that they would file for an interim protective order. No matter which way they report, there will be an investigation conducted. And again, that's to gather the evidence and statements from both parties. Once that investigation is completed, the case file will be transferred to the state's attorney's office, and that's the attorney for the state. They have what's called prosecutorial discretion, meaning they decide whether to file criminal charges and what charges to file. Ultimately, again, it is the state's attorney's job to present the evidence and proceed with the case if that's what they decide to do. The victim has no control over what evidence is being presented, what witnesses are being called, or how to proceed. And once charges are brought, that leads to the prosecution, and that's where the trial happens. There might be some plea offers, some negotiations, things like that. So some of the common sexual offense charges that are filed against perpetrators include rape. Rape, there are 2 degrees of rape, first and second degree. Both of them include some type of vaginal intercourse or sexual act, which is penetration, with force or threat of force, and without the consent of the survivor. The difference, though, is that rape in the first degree requires one or more aggravating factors. And those aggravating factors may include using a weapon, suffocation, or strangulation. It may be a threat of death or kidnapping. And a maximum penalty for rape in the first degree does include life imprisonment or life without parole. Rape in the second degree, however, does not require any aggravating factors. So it may just be vaginal intercourse with a force or threat of force without the consent of the survivor. And the maximum penalty for rape in the second degree is 20 years. Both of these charges are felonies, and that means that there is no statute of limitations. There's no deadline to file for criminal charges for rape in the first or rape in the second degree. There are also 2 degrees of sexual offense. So sexual offense in the third degree is a sexual contact, which is generally groping. There does not need to be force or proof of force, but it's still without the consent of the survivor. Sex offense in the third degree does include the requirement of aggravating factors. Again, that's use of a weapon, strangulation, suffocation, threat of death, things like that. And the maximum penalty is 10 years. Sex offense in the third degree is a felony, so again, there's no deadline to file that charge. However, sex offense in the fourth degree is a sexual contact, so groping, with no proof of force, and it is without the consent of the survivor. No aggravating factors are required, and that is a misdemeanor, which means there is a deadline to file that charge, and usually that's 1 year from the date of the incident. The maximum penalty is 1 year in jail or $10,000 fine. Stalking may also be a charge that is filed against a perpetrator. And stalking is defined as a malicious course of conduct that includes approaching or pursuing the survivor when the perpetrator intends or knows or reasonably should know that the conduct would place the survivor in fear of serious bodily injury, rape, sexual offense, false imprisonment, or death, or that the perpetrator intends, knows, or reasonably should know that the conduct would cause the survivor serious emotional distress. Stalking is a misdemeanor as well. So again, there is a deadline to file, but a penalty, the maximum penalty is 5 years in jail and a $5,000 fine. Stalking does include conduct that is in person or by electronic communication, or even using a device to track or locate the survivor without the survivor's knowledge or consent. So use of Apple AirTags or similar devices can be considered stalking as well. Harassment is a very common charge that may be filed as well. For harassment, the perpetrator has to follow in a public place or maliciously engage in conduct that alarms or seriously annoys the survivor. And there must be an intent to harass, alarm, or annoy the survivor after receiving a reasonable warning or request to stop. And that contact or that conduct must be made without a legal purpose. It is really important when filing charges for harassment that the survivor identify exactly when they told the perpetrator to stop and how they told the perpetrator to stop. It is generally recommended that request to stop be made in writing so that it is much easier to prove, hey, here's the date and time. I told him to stop contacting me, stop following me, whatever the action may be. Harassment is a misdemeanor. So again, there is a deadline to file for harassment criminal charges. And for the first offense, a perpetrator can face up to 90 days in jail and or a $500 fine. But for every subsequent conviction of harassment, the perpetrator may face 180 days in jail or up to a $1,000 fine. Revenge porn is a growing concern, especially in college students. So revenge porn is knowingly distributing some type of visual representation of another person that displays the intimate parts or that person engaged in a sexual activity. And that visual representation may be pictures, videos, things of that sort. There must be an intent to harm, harass, intimidate, threaten, or to coerce the survivor. The perpetrator must have known or should know that the survivor did not consent to the release of those visual representations, or there must have been a reckless disregard as to whether the survivor consented to the release. And the survivor must have had a reasonable expectation that the image would have remained private. Revenge porn is a misdemeanor. So again, there is that deadline, that statute of limitations to file. Again, usually that's a year. But if a perpetrator is found guilty for revenge porn, they can face up to 2 years in jail and or a $5,000 fine. A lesser used criminal charge is sextortion. Sextortion is blackmailing or threatening another into performing a sexual activity. And that actually includes making images or videos, recordings, whatever it may be, of a sexual activity. It does not include, or it's not required to include the threat of force, which is covered by the rape statutes. So those rape in the first degree and second degree did require some type of force or threat of force. For sextortion, it can be a threat of emotional distress, or it can be a threat of damage to property, things like that. And this is a really underused criminal charge because um, it's sometimes difficult to prosecute on this. It does apply to sex acts as well. And so there are usually some crossover between sextortion and the sexual offense or the rape statutes. And for all of the crimes that we just discussed, the victim could be a minor, but there are some crimes that are crimes simply because the victim is a minor. And those are crimes that are based on age or relationship between the perpetrator and the child. So for child sex abuse crimes, it's a prohibited act. My apologies. Sexual acts against all persons under 18 are prohibited if there is some type of relationship between the victim and the perpetrator. So that may be that the perpetrator is a parent or a caregiver, a nanny, some other household member, things like that. Under the fourth degree sex offense that we discussed earlier, a person in position of authority is prohibited from engaging in a sexual act or sexual conduct with a minor. And a person in position of authority is defined as somebody who is over 21, who works for the child's school, or exercises supervision over the minor. In 2023, the Maryland legislation closed the last loophole to this sexual offense. And so now fourth degree sex offense also includes, for a person of authority, it's anyone who works for or volunteers at a program for the child and is at least 22 years old. And that can be at a daycare, a day or overnight camping, or some type of sports, music, or dance instruction or training. For age crimes, it's important to note that the age of consent for sexual contact, which again is that groping, is 14. The age of consent for vaginal intercourse or sexual acts is 16. And for most of the age crimes, there has to be a 4-year age gap that is required between the survivor and the perpetrator. And usually that means that the survivor is at least 4 years younger. That's different with the new person in authority law, and that requires a 6-year age gap for certain adults. Depending on the types of crime against the children, there may be a higher penalty if the adult is over the age of 21. Once criminal charges are filed against a perpetrator, the victim has several rights that come into effect as the victim of a crime. The most important ones that I want to highlight are that the victim has the right to be informed about the criminal case. That is the status of the case, any court hearings, whether there is a plea offered, things like that. The victim has the right to be present at any court hearing that the perpetrator or defendant has the right to be at. Some of those hearings are not necessarily required to be present. A victim's never required to be present in court unless they receive a subpoena or a summons. However, they do have the right to be present if they so choose to. They also have the right to be heard on any matters relating to that criminal case. So if the state's attorney wants to offer a plea offer or try to reach some agreement, the victim has the right to be heard on his or her opinion of that plea offer, and also has the right to address the court when it comes to sentencing, and provide a victim impact statement to tell the court exactly how this crime has impacted them. Restitution is also a right through a criminal case, and that is a monetary punishment for the crime that was committed against the victim. It does require proof of cost. So there must be some receipts, out-of-pocket expenses that can be shown. And lastly, the victim has the right to representation, which is a crime victim's rights attorney, and that attorney can help facilitate communication between the state's attorney's office and the victim and help ensure that the victim's rights are being enforced. Again, for restitution, all crime victims have the right to ask for that restitution. And it must be a provable expense, so there must be some type of receipt. It does not include emotional distress, but it can include like property damage or if there was a therapy cost, things like that. And then that crime victims' rights representation, again, it's to ensure and enforce the crime victims' rights. It's to ensure that confidential or privileged materials are not released without some type of legal reason. So oftentimes, defense attorneys will subpoena or request the victim's medical records, and a crime victim's rights attorney may be able to prevent the release of those records. It's also important to note that the victim does not have any type of privilege with the state's attorney's office, because the state's attorney is not the victim's attorney. The state's attorney is the attorney for the state. Another financial reimbursement option is the Criminal Injuries Compensation Board in the state of Maryland. So victims of violent crimes and sexual assault can file for reimbursement of certain out-of-pocket expenses that they sustained as a result of the crime. It does require that there be over $100 of out-of-pocket expenses. The victim must report the crime and cooperate with law enforcement. Again, a conviction is not necessary. And if criminal charges are not filed, that doesn't prevent the victim from requesting this reimbursement through the Injuries Compensation Board. It will only cover provable expenses, not emotional distress. So again, there must be some type of receipt, but it will reimburse for medical expenses, funeral costs, crime scene cleanup, lost wages. It does not include that property destruction, moving costs, or court fees. So if there is any property destruction and there's a criminal case, if the defendant or the perpetrator has financial means, it is best to request that reimbursement through the restitution in the criminal case. Lastly, I want to note that the Criminal Injuries Compensation Board is the payer of last resort. And that means that they will only make payouts after the survivor exhausts all other options. So if the survivor had the option to receive restitution through the criminal case, and the survivor did receive money restitution through the criminal case, the Injuries Compensation Board may or may not pay out, depending on how much restitution was received and what other expenses the survivor is facing as a result of the crime. The last thing I want to touch on is actually a civil, another civil option that victims may exercise. A tort is a lawsuit directly against a perpetrator for the negligence or injury that the survivor sustained. The most common torts that are filed are on assault and battery. Assault is the threat of the physical touching, and the survivor has 1 year from the date of the incident to file on the grounds of assault. Battery is the actual physical touching, non-consensual touching, and the survivor has 3 years from the date of the incident to file on a battery. For victims of child sexual abuse, Maryland recently eliminated the statute of limitations. So if the incident occurred in 1992 and the victim was a minor, the victim does still have the opportunity to file a lawsuit against the perpetrator directly, even though it's been quite many years since the date of that incident. However, there are legal challenges that are underway. So that statute of limitations may come back, or the law may change and say that only future child sex abuse may have no limitation. And again, just as a reminder, this is a civil option, so the ultimate goal is some type of money damage. So victims and survivors can call SALI at any time. And again, if there are questions that you as providers have, we can provide some legal technical assistance as well. It is much better to ask questions in advance than to have survivors think that they don't have options. So I would highly recommend that you consider even just touching base with us to see if there are options or how we can assist. And lastly, this is the contact information for MCASA, again, the Maryland Coalition Against Sexual Assault, and SALI, which is the Sexual Assault Legal Institute. And thank you so much for attending this training today. Hopefully you did learn a lot about the legal options that victims may have.